So thanks for that great introduction, Lavinia. I should say, the court's term is already happening. Today is the last Monday in October. As many people probably know, the court typically begins on the first Monday in October. So they've already had 2 weeks of hearing cases. But I think that Vic and I will agree that the court has a pretty light docket in terms of interesting cases so far. We're going to try to talk about the most interesting ones and then maybe preview some of the stuff that might be coming down the pike. So I'll stop there for a moment to let Vic say hi as well.
Thanks. Good to see you, Mike. Good to be with you. Thank you, everyone, for attending today. Yeah, Mike, I think, is right that the court so far has not granted review in a large number of cases that we would call blockbuster. Of course, most every case the Supreme Court decides is important, but a lot of them are important in a kind of a more legalistic and less kind of headline-grabbing way. The only other point I'd make is that at this time last year, the two cases from last term, the term that ended during the summer, that I think were far and away the most important two cases, Trump versus Anderson, the case involving whether the state of Colorado could exclude Donald Trump from the presidential ballot on the ground that he had engaged in rebellion or insurrection in violation of Section 3 of the 14th Amendment. And then, of course, Trump versus United States, the case involving presidential immunity. Neither of those cases were yet on the court's docket. So the fact that the docket for 24-25 looks pretty light right now doesn't mean that by the spring and the summer, we won't be looking back on some major cases, especially given that we have an election coming up next week, and who knows what kind of litigation that might generate.
Yeah, so let's dive in. I'll start with what I think is the biggest case that is on the docket so far. This is a case called United States against Scrimetti, which will be argued in early December, which was recently scheduled. That's interesting that they scheduled it for early December because that ensures that the current Solicitor General, Elizabeth Prelogar, will be the one who argues it. And she's a superb advocate, but also in the event that there's a change of administration, there will be a change of administration in the sense that President Biden will no longer be president. But in the event that Donald Trump ends up as president, there's a possibility that the government changes its position. But for now, the way this case comes to the court is it involves a ban by Tennessee on what is sometimes called gender-affirming care for minors, including puberty blockers and hormone therapy. Despite what you might hear from politicians, minors really never have gender confirmation surgery. But this is a ban on these other forms of care. Tennessee and about half of the other states in the union have enacted these bans in the last several years. This is a case coming from the Sixth Circuit, which upheld the ban and rejected an equal protection challenge. And I think part of what's significant about it is that, it's obviously significant in terms of where the court is going to go on trans issues. But in addition to that, the Sixth Circuit said that only rational basis scrutiny, the lowest level of scrutiny, applies to this ban, which is, at least on its face, in some tension with a Supreme Court decision from 2020, Bostock against Clayton County, that said that for purposes of Title VII, which is a statute, not the Constitution, but it has some of the same structures, purpose of Title VII, discrimination on the basis of transgender status is sex discrimination. And of course, under the court's equal protection jurisprudence, if a state discriminates on the basis of sex, then it has to satisfy heightened, or sometimes called intermediate scrutiny, not this lowest level of scrutiny. So at the threshold, there's a question of what level of scrutiny applies to discrimination on the basis of transgender status under the Equal Protection Clause. Part of what's significant about the case, of course, is that Justice Gorsuch, surprising a lot of people, wrote the court's majority opinion in the Bostock case, and there's been this lingering question ever since: would he translate that to the equal protection context? One reason to think he might not is that in the 2023 case, Students for Fair Admissions against Harvard, which involved both equal protection and Title VI, which is the parallel provision of the Civil Rights Act. Justice Gorsuch wrote a separate concurrence saying, well, maybe we should treat the statute and equal protection differently. And I read that as sort of teeing up and reserving his option to treat discrimination on the basis of transgender status and sexual orientation differently for statutory purposes and constitutional purposes.
So let me build on what Mike, let me start by saying I agree that the fact that Bostock came out a certain way under a statute doesn't tell us much about the constitutional doctrine, in part because Gorsuch's statutory analysis in Bostock was keyed to the word on account of or on the basis of sex. And of course, the 14th Amendment and the Equal Protection Clause don't have that term. Indeed, there were justices until very recently on the Supreme Court, such as Justice Scalia, who questioned whether the Equal Protection Clause should apply to gender-based classifications at all, and whether the Equal Protection Clause was only about race, given the history of the 14th Amendment and the Reconstruction era. So I actually don't easily see a majority of 5 justices rallying around the equal protection claims brought by the minors in this case. Couple of other points. It's kind of interesting to me that we're talking about the standard of review that applies in a case involving transgender equality, and the Supreme Court has never even really clarified what the standard of review that should apply under the Equal Protection Clause for discrimination against gays and lesbians, because the only cases we have involving same-sex equality involve marriage, which is a complicated interplay of liberty and history and equality. I tend to think, actually, that Obergefell and the marriage case was really more about equal protection than it was about substantive due process, but people might disagree with me on that. I think equal protection was the cleanest way to justify that correct case. But it's interesting that the court kind of has leapfrogged questions about whether states can discriminate against gays and lesbians in public employment or in jury selection and things like that, to go to what I would consider a more exotic or more cutting-edge kind of question of the kind raised by this case. 2 other quick points. One is, surrounding these kinds of bans, there are 2 sets of issues. One are equal protection issues on behalf of the children themselves. And second are substantive due process issues surrounding the rights of parents to decide the medical care of their children. And it's interesting that the court granted review on the equal protection set of issues here, but not on anything involving parental rights. And I'm not sure exactly what to make of that. But it makes it easier for the court to repudiate the equal protection claim without really wading into the more complicated question of when parents have rights over the upbringing of their children under due process, which is something that more is contentious, as we saw in Dobbs. And the final question I'd have, and I'd be interested in Mike's reaction, I'm not altogether clear why the court granted in this case if it's going to affirm. Because as you pointed out, Mike, the Sixth Circuit upheld this ban. It didn't seem particularly unconventional what the Sixth Circuit did, given the makeup of this court and one's expectations about how equal protection challenges will fare in this court. So I'm just a little puzzled at why they took the case, unless they wanted to really kind of maybe surprise me.
Right. So I guess one possibility is a surprise. There have been district court opinions coming out the other way. But so far, none of them has succeeded at the appeals court level. So there isn't a circuit split. I don't actually know. I mean, I'm also quite interested. I should say on the substantive due process side, right, one of the interesting things about the parental rights claim is it's sort of a double-edged sword. I was talking the other day to a lawyer who does a lot of transgender equality cases, and they were expressing considerable skepticism and almost fear of the parental rights claims, for fear that, it's not clear whether you're talking about the rights of parents on behalf of their children who are in agreement with them as against the state, or the rights of parents as against their children. And so what this advocate was worried about was, well, you tee up the parental rights claim, and maybe you end up with the court saying, well, parents have a right to, send their kids to conversion therapy or something else. And this has always been a bit of an ambiguity about parental rights, right? That is, there's a when the parents are doing what the kids want them to do, there's an obvious libertarian cast to the whole issue. But when the parents are doing something to the kids and the kids either object or they're too young to really have an opinion, then parental rights look quite different. Okay, so let's move on to some of the other cases. I want to talk about two cases that the court has already heard argument in. One of them is the so-called ghost guns case. This is Garland against Vennerstock. And here, a ghost gun is basically a kit from which one can assemble a gun. And the question is whether the federal law that regulates firearms, to the extent that it does, obviously lots of firearms are legal in this country, but to the extent that it does, which is, basically forbidding machine guns and in this case talks about projectiles or explosives, right? Whether that applies to the kits and not just to the guns. And what's interesting about this case, to my mind, is that if you take a sort of layperson's approach, you say, well, is a gun kit a gun? Well, no, it's a gun kit. But the statute and the regs are pretty clear that, no, the term gun is a term of art, and it includes these gun kits. I'm simplifying somewhat. And so there's a pretty good sort of plain vanilla statutory text argument here that a gun kit is a gun as a term of art in a way that was less clear last term in the bump stocks case, right? You may recall that in that case, the question was whether a semi-automatic rifle equipped with a bump stock, a mechanism that harnesses the recoil from the gun against the shoulder, whether that counts as a machine gun, and the court ended up saying, no, it doesn't. Justice Alito, interestingly, wrote a concurrence in which he said, well, I can't think of any good reason why Congress would want people to be able to circumvent the prohibition, but that's what they said. So it'll be interesting to see what they do. From the oral argument, it looked like they were pretty sympathetic to the government's argument that here the statutory text is clear. Case doesn't directly involve the Second Amendment, and the bump stock case didn't either, but there's a kind of shadow of the Second Amendment whenever guns are involved.
Yeah, I think all of that sounds right to me. And the reason why these gun kits pose problems is because when you buy a gun kit and you put together the gun, it doesn't have a serial number on it the way guns that are manufactured in traditional factories do. And so it's a lot harder to trace, which guns actually are involved in crimes and the like. I take Mike's point that there may be a stronger plain meaning statutory argument in this case than the bump stocks case, but I actually thought that there was a decent plain meaning argument in that case, and there's some ambiguity in this case given the definition of a frame and whether a frame is something that has to inevitably shoot projectiles or may be made to shoot projectiles. So I think, in most every statute, you can kind of create some ambiguity because that's the nature of language and words. They're unfortunately, they're not like computer code. There's always some imprecision and some different shadings and meanings you could attach to them. So it'll be interesting to me to see whether the court simply locks into a mechanical, well, this is what the statute says, and that's why the federal government wins here, or whether they draw a little bit more on the obvious purpose behind Congress's regulation of guns and requirement of serial numbers, because that would be in some tension with the mechanical approach they took in the bump stocks case.
Yeah, so I take that as a friendly amendment. I didn't mean to suggest that the language is ever perfectly clear. You wouldn't get cases going to the Supreme Court if it were just a matter of reading comprehension. Okay. I want to talk about one more case that was argued earlier this month. This is a case called Glossop against Oklahoma. So court watchers might recognize the name Glossop. That's because Glossop was up at the court once before in a case called Glossop against Gross. In that case, he was challenging the method of execution by which Oklahoma was going to execute him, namely the drug protocol that Oklahoma was using. And it produced some pretty dramatic Eighth Amendment law, in particular, a statement by the court that said that if you're going to challenge a method of execution as inhumane and thus a violation of the prohibition on cruel and unusual punishments, you have to point to a more humane available alternative, which at the time I described this as a kind of Foucauldian obligation, right? That Foucault has this notion that the worst forms of oppression are those in which you make the victim internalize the harm. But in any event, that was a number of years ago, and because the wheels of justice move slowly, although Glossop lost, he wasn't executed. In the meantime, there was a new attorney general of the state of Oklahoma, a conservative Republican, but, guy committed to the rule of law. And so one of the first things he did when he came into office was he ordered a review of all of the existing death penalties. And the vast majority of them, he said, okay, these are fine, they can go forward. But in Glossop's case, when he looked at the original prosecutor's files, he found evidence of so-called Brady material, that is to say, potentially exculpatory information, that had not been turned over to Glossop's attorneys at the time of trial. And Glossop significantly has consistently maintained his innocence. There's no doubt that the actual killer in the case was a man named Justin Sneed, but Sneed had maintained at trial that he performed the killing because Glossop hired him to do so. And Glossop argued, no, he didn't, that Sneed was just trying to pin it on him in exchange for a deal where Sneed avoided the death penalty. And what the Attorney General discovered was actually there's some evidence in the files that casts doubt on Sneed's story, that the police and prosecutors had reasons to doubt, although the evidence is a little bit ambiguous if you look at exactly what their notes were. And so he wanted to give him a new trial. But, even though it's the executive branch that brings the prosecution and ultimately carries out the sentence, in Oklahoma, as in most states, once there's a judgment, you can't just let it go. Now, the way that you could would be through executive clemency, of course. And Glossop has applied for clemency, but hasn't gotten that. But the Attorney General had to go back to court and ask the Oklahoma court, hey, can I get a new trial? And they said no. They said, we don't think this evidence is that effective. And moreover, we think there's an adequate and independent state law ground for upholding the conviction and sentence, namely that the motion wasn't timely. I should say that Glossop doesn't just rely on the Brady violation. There's also another case called Napoo against Illinois about putting on perjured testimony. There's some evidence that the prosecution knew that Sneed's story didn't hang together. But the Oklahoma court said, you know what, this isn't enough. And so you're in this strange position of the Oklahoma Attorney General and and Glossop himself are on the same side in the U.S. Supreme Court. And so the court appointed, an amicus basically to represent the other side. So it's in a way, it's the Attorney General of Oklahoma and Glossop against the Oklahoma courts.
And what was your reaction to the oral argument? Did you follow?
Well, I thought so I was surprised about how much time they spent on the adequate and independent state ground issue, especially because one of the crucial factors for adequate and independent state ground would be that the state judgment is adequate. And for it to be adequate, you'd have to say that it was untimely here. And they'd never previously held that one of these motions was untimely when supported by the state, as it is here. And moreover, how could it be untimely given that he couldn't have known about the violation because this was evidence in the files that were not turned over to Glossop? There was something like 7 boxes that were turned over, but this was in a box that wasn't turned over. And so I just think that, I could see the court rejecting Glossop's claim on sort of harmless error grounds if they don't find that this really rises to the level of actually casting doubt on the conviction in light of other evidence. And as Justice Thomas was pressing, there was some ambiguity in what the handwritten notes meant. But the amount of time they gave to the adequate and independent state ground theory struck me as very peculiar.
So yeah, that's it's a very interesting case. I would add that this question about disagreement between the branches of government at the state level is something that we saw in another case that hasn't gone to the U.S. Supreme Court yet, but from Texas, where there's I can't remember the name of the defendant, but he's on death row and he was scheduled to be executed, and there was some newly discovered evidence that suggested that he didn't necessarily intend to shake the baby to death. It was a shaken baby case. And the Texas legislature, or a committee thereof, subpoenaed the defendant to testify in front of the Texas legislature. And the question was whether that should generate a stay of the death penalty sentence to give the legislature time to hear from this individual. So there was obviously an attempt by the legislature to kind of block the execution that the executive branch was about to perform. And the Texas Supreme Court granted a stay, at least for a long enough period of time for them to sift through this intrastate separation of powers question of whether the legislature could effectively delay an execution by asking that the sentenced person testify in front of the state. So to me, it's interesting that, the kind of cases that are bubbling up to the top are these cases that are very kind of far afield from the core death penalty issues that I think, when I clerked for Justice Blackmun and Mike, when you clerked for Justice Kennedy a little thereafter, the court was taking a lot more death penalty cases, and they seem to be much more, if not garden variety, they seem to be more basic. These are kind of much more creative claims that are making their way to the top.
Yeah, I think that's right. I mean, part of it, of course, is that in those days, there were still some justices who were pretty squarely against the death penalty. And then you could sort of cobble together a coalition from justices who were concerned about race discrimination and its enforcement, those who were concerned about due process issues. Now, I think, with the possible exception of Justice Barrett, I don't think you can really peel off any of the conservatives. So it's almost impossible to get to 5 on a conventional capital case, unless, of course, it's, sufficiently really, really egregious, in which case it's, you're not going to get that many cases like that that'll actually make it where the condemned person loses in the lower courts, except maybe in the Fifth Circuit. And so, I guess it's not surprising that these are the kinds of cases they're getting. But it is sort of interesting that they're getting cases at all, right? They could have just said, no more capital cases. Especially when you consider how few executions there are now. We're way down. We're at like 10 to 20 executions a year for the last decade, including during the Trump administration. So there are just many fewer executions. And it might be that we've reached a kind of equilibrium where the death penalty isn't completely abolished, but it's very much on mute. Okay, I want to mention some cases that have not yet been scheduled, but that are on the docket. So there's a case that's close to, I think, a lot of stuff that's in the news for other reasons. A case called Barnes against Felix, in which you have a traffic stop, and police officer is having an exchange with the driver. The driver says that he's got some stuff in the trunk. The police officer has some suspicions. And at some point, the driver, either the car starts to move on its own, or the driver is driving away, and the officer is yelling at the driver to cut it out, and then shoots him and kills him. And it's then a wrongful death action by the parents. And the question is, how do we judge the reasonableness under the Fourth Amendment of what the police officer did? And what the Fifth Circuit did, applying their previous doctrine here, was to say, well, we apply something called the moment of the threat doctrine, which means they don't look at the whole interaction and whether the officer acted unreasonably in essentially escalating the conflict to the point where maybe some kind of confrontation that wouldn't have otherwise occurred did occur. You only look at the exact moment when the officer is faced with a car that's potentially going to run him over, even though he's on the side. It's a little hard to tell, and they say so. The plaintiff's family loses. I was a little surprised that the court took it. The Fourth Amendment has traditionally been an area where some of the conservatives have been a little bit more libertarian. And so maybe they're going to say, no, this whole moment of the threat idea is wrong. You got to look at these things holistically. And by the way, it's not obvious that moment of the threat will always work to the advantage of the police. It could be that in the moment of the threat, there isn't that much of a threat, but the pre-existing context actually makes it look like more of a threat. And so that, it's a relatively small case, but given all of the attention that has understandably been paid to interactions between police and citizens and the potential for violence, it could be a window into some of that.
So I would add just one fact to the case. So at the time the car had started to move forward, and it is unclear exactly, where the officer was and how he might have been run over. But when the driver had opened the car door ostensibly to go into the trunk to get the documents that he said might be there, at that point the officer kind of put his leg into the car in a way that increased his danger. And arguably, he's the one who created a risk of him being run over by that unwarranted aggressive act of sticking his body into the car. So one reason they might have granted is because there is this enduring circuit split, it seems. The Fifth Circuit was kind of in the minority of circuits, and other circuits had adopted a more conventional totality of the circumstances test. Indeed, I think one of the judges on the Fifth Circuit who was following Fifth Circuit law here wrote a separate concurrence. Higginbotham concurred in his own opinion, saying this circuit split needs to be resolved. So maybe it was just respecting that thing. The other thing I would say is Mike is definitely right that it's not clear which way this moment of the threat doctrine will cut in a given case. On the facts of this case, I would think even if you adopt a moment of the threat narrow focus, how threatening the movement of the car did depend on the larger circumstances of the stop. So the guy was stopped because his car had all of its traffic tolls. And so if you're stopping a car because of toll violations, as opposed to because, it's a stolen car or it matches the description of a car used in a violent crime, then I would think that background fact should inform the officer's assessment of whether this momentary motion of the car reflects a desire on the part of the driver to run him over, or maybe something more innocent. So even this moment of the threat doctrine, it's not clear analytically how much that doctrine should exclude everything that the officer should know beforehand about the nature of the interaction. So it'll be interesting to see what the court does, but it may be just a case where they need to clean up a circuit split. And I have to say, given the Fifth Circuit's kind of track record, and there's other cases from the Fifth Circuit that they granted on this term, if you're going to grant in a case where there's a split, you typically are going to do so from a circuit maybe that you want to reverse, and the Fifth Circuit seems a prime candidate in that respect.
Yeah, and Vic, you referred to the totality of the circumstances, which is, of course, the language that you see in just about all the other Fourth Amendment cases. So it is really a peculiar doctrine, this notion of moment of the threat. Okay, I want to talk about another case that's been docketed but hasn't yet been scheduled. This is Smith & Wesson against Mexico. So, politicians sometimes talk about the drugs and undocumented immigrants coming across the southern border. But Mexico has a gripe with the U.S. as well, and that is a whole lot of firearms go in the other direction. And this is a lawsuit by the government of Mexico filed in the United States saying that the gun manufacturers, it was a whole lot more, now it's down to two, but the gun manufacturers in the United States are deliberately creating firearms for the illegal Mexican market. And these are being used by drug cartels and other outlaws in Mexico to create, very, very serious harm. The key question here is whether this lawsuit is permitted by a federal statute called the Protection of Lawful Commerce in Arms Act, otherwise known as the PLCAA. And in order for it to be that, it must fall to an exception to the statute's general liability shield for firearms manufacturers. And this is the so-called predicate exemption. And it says that a lawsuit is not forbidden if it's an action in which a manufacturer or seller of a qualified product, that means a firearm, knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which relief is sought. The defendants had a whole bunch of arguments for why the Mexican lawsuit couldn't go forward, and the First Circuit bought a bunch of those arguments, but the one argument they didn't buy was that this doesn't allege any kind of statutory violation. The defendants had argued, among other things, that you have to have a statutory cause of action. You can't bring a common law cause of action. And that seems just plainly wrong, right? That is, the PLCAA is a statutory defense, but statutory offenses are often set up in response to common law causes of action. Now, the harder part for Mexico, of course, is actually establishing that they fall within the exception. But as I read the procedural posture of the case, since this is at the sort of the motion to dismiss level, that would be at least a matter for discovery, summary judgment, and ultimately for trial if it gets past summary judgment. There is evidence in the record of, I wrote a column for verdict when the case was first filed. There's evidence in the record of guns that the defendants manufacture where the handle will have specifically Mexican heroes engraved in or pictured on them. And so it's quite clear that at least some of these firearms are being targeted to a Mexican audience in violation of Mexico's drug laws, and in violation also of federal statutes that require certain licensing and other measures for exporting guns, and also there seem to be evasions of domestic gun control involving so-called straw purchasers who are buying here and then just taking the guns to Mexico. So this is another case, a little bit like the ghost gun case, right? Another case where you've got federal statute, you've got guns. It's not directly a Second Amendment case, but it'll be interesting to see to what extent this activates the conservatives' concern that they, sometimes express for the rights of lawful commerce in firearms, or whether they'll see this as no, these are people who are just trying to evade the law.
Yeah, so I think you're right. You have to look at all these cases against the backdrop of the Second Amendment and gun rights. But of course, this case also involves foreign relations of a sort, because you have another country that we want to kind of keep good relations with, complaining about the guns that are leaking across the border, and they need to be able to do something about it. I commend people to read Mike's column that he wrote for Verdict when the case first arose. In that column, Mike, I thought I read you to say that, you weren't optimistic that Mexico would ultimately prevail. But a moment ago, you said, given the procedural posture of the case and you think that their argument is strong on the merits, at least at this point. But you still are probably predicting the court will not rule in their favor.
Yeah, I mean, I think there's a decent chance that Mexico wins in the Supreme Court. Although I would point out, right, Mexico won below, so it's Smith and Wesson who had their cert petition granted. So that's not a good sign for Mexico. But I just don't see the argument, at least at the pleading stage, for why this doesn't fall within the exception. As I said, I think the harder place, and I think the place that Mexico is probably going to lose is, with the exception of these, purpose-designed guns, it's going to be hard to show that, a company that's manufacturing thousands and thousands of guns and some percentage of them make their way to Mexico is deliberately targeting the Mexican market.
Mike, you want to mention the other case involving foreign government? That's the Foreign Sovereign Immunities Act case.
Why don't you do that? Because I don't have that on my list.
Sure. That one is called Divas Limited versus Antrix Corp. And the question is whether a plaintiff who sues a country under the Foreign Sovereign Immunities Act has to establish minimum contacts with the United States before a federal court can exercise jurisdiction. And most every circuit has ruled that the minimum contacts test that we're all familiar with from first year of law school, civil procedure, before a federal court can exercise personal jurisdiction over a defendant, that does not apply to claims brought under the Foreign Sovereign Immunities Act, because Congress in that statute said unless there is a conferral of immunity on a foreign country can be sued in federal court. The Ninth Circuit read the Foreign Sovereign Immunities Act differently so as to include a requirement that the defendant, in this case, I think an Indian entity, would be had minimum contacts. And so we have, again, I think a circuit split, which might account for why the court granted in this Ninth Circuit case. I'm actually a little surprised that all the other circuits had poo-pooed the idea of a minimum contacts requirement. It seems like everybody agrees that there's no constitutional requirement that there be minimum contacts. It's entirely a question of what the statute means. But it'll be interesting to see what the court does with it.
Yeah, I mean, one of the interesting things about that is it sort of, a lot of the minimum contacts cases we know about are actually not technically constitutional cases. They're actually interpretations, if they're in federal court anyway, they're interpretations of Federal Rule of Civil Procedure 4K, which incorporates the territorial limits on service of process that apply to the states. But it's hard for me to imagine that the court's going to think about this without a kind of overhang of thinking about constitutional issues. Here, not so much due process, but more about the foreign relations and so forth. All right, let me mention one other case, and then we're going to talk about cases that could be coming down the pike. So this is Free Speech Coalition against Paxton. So Paxton, as you probably know, is the Attorney General of Texas. So Texas law requires a site that has at least a third of its content, which is material that is obscene with respect to minors, which is a lower threshold for obscenity than is for adults. But if a third or more of its content, obviously sexual content, is obscene with respect to minors, then it imposes age verification requirements, essentially. And the Supreme Court has not addressed a statute like this in 20 years, right? So there were two federal statutes that the court struck down in the relatively early days of the internet. So the earliest was in Reno against ACLU in 1997, and that was the Communications Decency Act. Then there was the Children's Online Protection Act, otherwise known as COPA, and that got to the court in Ashcroft against ACLU in 2004. And in those cases, the court applied a principle that they had derived from earlier cases involving sexual speech, which was basically that the government has an important interest in limiting minors' access to material that is inappropriate for minors, but it has to pursue it in a way that doesn't unduly constrain the access of adults. Again, we're not talking about material that is obscene with respect to adults, and so it's First Amendment protected. There's a great line in one of the earlier cases, pre-internet, I think it's Justice Marshall, in which he says that the government can't enact laws that reduce the material that's appropriate for the post box to those that are appropriate for a sandbox. And that's the sort of principle that's operating here. Now, this was challenged in federal court, was preliminarily enjoined, and then the Fifth Circuit reversed. And what they did was they said only rational basis scrutiny applies because there is not a right to transmit obscene with respect to minor material to minors. And that does seem, at least on its face, somewhat in tension with these earlier cases. And the Fifth Circuit tried to weave its way through those cases to say how, well, they don't really apply because there are certain distinctions between this law and those laws. I've got to say, it's hard for me to imagine the Supreme Court is going to affirm unless it wants to revisit its precedents involving sexual speech and or regulation of the internet. And there's some indication that at least some of the justices are interested in doing at least the latter based on the cases that got rejected on procedural grounds last term.
So yeah, Mike, you asked reasonably why this case wouldn't be a good candidate for summary reversal, because it seemed like the Fifth Circuit wasn't particularly respectful of the Ashcroft precedent 20 years ago. And you posited, as you just did a moment ago, that maybe the court wants to revisit this stuff. I think both could be true. They may want to revisit this stuff and they may just want to reverse as well, but they need to spend a little time doing it. But I found the Fifth Circuit's attempts to explain why minimum rationality review applies here, even purportedly conceding that adults have a right to have access to this information, pretty laughable. But I have to say, the Fifth Circuit continues to surprise me with its extreme results, as they had one on Friday in a voting case. But let me hear from you what you think might be coming down the pike with regard to the election, or the kinds of issues that we should be looking for, and the attitude the court might have.
Right. So we are just now nearing the end of what we would call the sort of pre-election challenges. I haven't looked at the materials yet, but according to SCOTUS blog, Virginia has filed an action in the Supreme Court seeking emergency relief so that they can put back in place their effort to purge the voting rolls. This was blocked on the ground that it violates a federal statute that requires a kind of freeze in the 90 days preceding an election. Virginia it's not typically listed as one of the six swingiest states, but it's not exactly a blue or a red state. It is kind of purplish in various respects, right? Currently has a Republican governor. I think the court is likely to reject the petition, but who knows? So that's right there. You mentioned the case out of Mississippi's, but I think what we're all sort of concerned about or anticipating are post-election challenges, and that could take any number of forms, right? So one thing I think we can think about is cases bubbling up through the state courts versus cases bubbling up through the federal courts. And in a way, the cases bubbling up through the state courts are almost certain to, at least result in some kind of petition, because in most states, the courts are part of the election apparatus, especially now in places like, Georgia, where you've got a state body and then local bodies that may not certify election results, even though that's supposed to be a ministerial task. So I think one of the things you're likely to see is state courts ordering election officials who don't want to certify results because they either believe or are opportunistically invoking claims of voter fraud or whatever else, like being told, no, you have to, and that's ministerial. I think that mostly presents issues of state law, but who knows, right? That could result in some sort of response. I think there are any number of other things that could happen, right? If there's, if the polls are closed because there are, when there are still long lines, there could be claims in state or federal court saying keep these open because, you're engaging in various Voting Rights Act violations. And then the big one, and I'll leave this for sort of fuller discussion in a moment, are cases that might come out of what happens after the votes have been tallied. But if there's an attempt by former President Trump to do what he attempted to do in 2020, which is to get state legislatures to negate the result of the statewide election. I think most of these circumstances are going to involve sort of aggressive actions by former President Trump and those supporting him, with the Harris team going to court to try to block it. But you can imagine some cases having the opposite configuration, depending on what's happening on the ground.
So in that regard, let me commend people to take a look at a column that Mike wrote for Verdict a week or so ago, in which he kind of looked back at Bush versus Gore and the era since, and suggested that the status quo, the candidate who's playing defense is going to, at least arguably, is in a better position. That even if you think a court is an aggressive court, as it was in Bush versus Gore, it was not irrelevant that it was Bush who was leading in the early go-rounds, and it was Gore who was asking for the recounts that created the constitutional questions, according to the court. That who's kind of challenging the state law status quo matters. So let me just big picture for a moment. I think we're probably in the Purcell window now, where the Supreme Court is not going to change the status quo of the election rules that are in place and how people are planning that the election will take place a week from tomorrow. Now, sometimes the status quo is hard to identify. So the Virginia case may present that. Is the status quo, these voters being purged or not being purged? But insofar as of today, they're not purged, because of actions by election officials or by by lower courts, I would expect the U.S. Supreme Court to decline to step in to change that at this point. That leads to kind of disputes that might arise afterward, and Mike kind of mentioned different kinds. Disputes that are brought after the election that involve the manner in which the election was conducted, I think are weaker candidates for federal court intervention and the U.S. Supreme Court intervention under the Purcell idea. Because the Purcell doctrine basically says we need to have the voters and the campaigns and the election officials have clarity about how the election is going to operate going into an election. And if people are relying on the clarity of those rules going into an election, then you can't very well change the outcome afterward by saying that those rules going in were themselves invalid. So Mike mentioned a Fifth Circuit case I'll describe here in a moment. The Fifth Circuit just ruled on Friday that Mississippi's statute, which permits votes to be counted so long as they are postmarked by Election Day, even if they arrive a few days after Election Day into the hands of election officials, that statute violates federal statute, which designates the first Tuesday after the first Monday in November as Election Day. I think the Fifth Circuit is dead wrong. I think they should be reversed when the U.S. Supreme Court takes the case. but I don't think that's something that would be implemented. The Fifth Circuit's ruling is not going to be implemented before next week, and nor can Republicans challenge after the election is held votes that were postmarked by Election Day but came in afterward on the ground that's preempted by this federal designation of Election Day. Because if the voters had an expectation that they could drop their ballot in the mail on or the day before Election Day, recognizing it'll take a few days to arrive, then for the same reasons that you can't change that right before the election under Purcell, you can't revisit that after the election. Now, cases about certifying and counting votes that are already in the bank, those are the kinds of things that I think we have to watch out for. And I do think that the Harris team is not going to be as aggressive as the Trump team, but we'll have to wait and see. There's one big category of additional disputes that I want to put on the table, and that's claims that state courts are violating federal law by somehow distorting or manipulating state law under this so-called residue part of Moore versus Harper. That was the independent state legislature case. The court in Moore versus Harper repudiated the idea that state courts were disempowered from enforcing state constitutions, even as regards federal elections. That is to say, that state constitutions can regulate federal elections, and governors and state legislatures have to respect that. But at the end of the opinion, the court said in Moore versus Harper, of course, states should not go beyond ordinary judicial review in enforcing state constitutions. They shouldn't be overly aggressive in a way that they're evading federal constitutional rights or the provisions of the federal Constitution that speak to the regulation of federal elections. I've written extensively why I don't think there's much left to that after the court repudiates ISL, the independent state legislature theory. Because if you ask what right there exists under the federal Constitution after ISL is repudiated, the only federal right that exists is the right to have states follow state law. That's the only right that's left, that states have to live by whatever state law is. But of course, state courts are the master interpreters of state law. And if a state court says the state constitution means X, it's going to be very hard for the U.S. Supreme Court to say, well, you can't say the state constitution means X because it's not sufficiently grounded in the text of the state constitution, or you're playing fast and loose with interpretive principles, because the U.S. Supreme Court interprets the U.S. Constitution in a way at odds with its text in countless areas. So I think that there's really not that much running room left after Moore versus Harper, but we'll see in the next month whether people try to exploit it and try to get the court to be involved.
Yeah, so I sure hope you're right about that, and that is certainly my best read of both the Constitution and Moore v. Harper. But there is language, especially in Justice Kavanaugh's opinion, right, suggesting that what they're doing is adopting the rationale of the Rehnquist concurrence in Bush v. Gore, which is, as you say, it's this sort of residual. It's not the fully robust ISL, but it is a kind of shadow ISL. And
except here's the problem, and even Thomas points this out, that you can adopt a deferential test. You can adopt language from the Rehnquist concurrence. But the Rehnquist concurrence, the reasoning of the Rehnquist concurrence was directly repudiated by the majority opinion that had 6 votes, including Barrett. Forget Kavanaugh. He wasn't even necessary to it. Because remember, Rehnquist said what the Florida court that did wrong was it disregarded the intent of the Florida legislature. But when you repudiate ISL and you say a state constitution can override the elected legislature, then that language from the concurrence is kind of hanging out there in the ether without its foundation. So my big takeaway is, if you're going to say a state court is evading state law, is manipulating state law, is contorting state law in a way that runs afoul of the elections clause, you almost have to say that the state court can't apply its ruling even to state elections. Because if a state court is making up the meaning of the state constitution, maybe that shouldn't apply in a federal election, but neither can it apply in a state election. And I don't see Roberts, Kavanaugh, and Barrett having the stomach to tell a state court, you can't interpret the state constitution in a particular way so as to govern your governor's election.
Yeah, again, I hope that's right. Let me just say one other word about how this all might shake out. So that's all about, the state court interpreting existing election law. One thing that, you could have, I adverted to this before, is after the election, let's say the Wisconsin legislature decides that it's not going to be Wisconsin because Wisconsin, they don't have a Republican governor.
North Carolina General Assembly.
Yeah, right. Well, they also have a Democratic governor, but Georgia, right? The Georgia legislature, with the governor's approval, says, you know what, our election was marred by fraud. We are going to now just assign our voters to Trump. And let's say the prior count suggested that they went to Harris. Now, under the Electoral Count Reform Act, they can't do that. But suppose Congress doesn't follow the Electoral Count Reform Act. Does the Supreme Court treat that as a non-justiciable political question if Harris sues? If they reach the merits, do they say the Electoral Count Reform Act is unconstitutional because it goes beyond what the power that Congress has under Article 2, Section 1, which is to make rules governing the timing of presidential elections? So I'm quite concerned about what happens in Congress in the event that there's some, dispute over what's going on in the states. Again, last time that didn't go anywhere, but part of the reason it didn't go anywhere, I think, was that they actually got to the debate on it after the January 6th insurrection had happened. And so some of the most aggressive Republicans in the House and Senate were pulling their punches a little bit because in the immediate, it was literally that night after the Capitol had finally been cleared when they reconvened. I don't think there was the stomach to do that. I'm not sure what happens. A lot of this depends, of course, on what happens in the congressional elections, because this happens after the new Congress is seated, but while Biden is still president. Of course, Vice President Harris is presiding over all of this, which just makes the whole thing even more surreal. I think my best guess is the Supreme Court stays out. But staying out, again, as I said, staying out very much benefits whoever is on defense, whatever the status quo is coming out of the political branches.
So just two quick thoughts on that. First, it would be rather rich for the court to invoke the political question idea and stay out here after Bush versus Gore. So why wasn't Congress the right body to wade through the stuff there? And it is here. But just as you optimistically hope that I'm right about the residue of Moore versus Harper, and I think I am, I'm going to optimistically say I don't see Georgia being such a state. I don't see the governor of Georgia going along with anything particularly aggressive in this regard. I think he'll leave it to the election officials to sort out who actually got more votes, and he'll stand behind that. And as you point out, Pennsylvania, Wisconsin, Michigan all have Democratic governors. So I'm not sure there is one of the swingy states that matters where this is a real likelihood to happen.
Right. And to tie those together, in order to make it happen in a state like Wisconsin, where you've got a Republican legislature and a Democratic governor, you need ISL to be in play. And if it isn't, then it doesn't happen.
All right. Well, I think we're at the bottom of the hour, so we should thank our guests and our hosts for putting this on. And Mike, as I said, I always enjoy spending time with you.
Absolutely, likewise, Vic. Great to do this with you. All right. Thank you all.
Back to you.
Great. Thank you guys so much. Do you guys have any additional thoughts maybe about any potential cases that you're like, maybe if I had a little more time, I could discuss a little bit more, anything like that before we move on?
Stay tuned, and maybe Justia will need to convene an emergency discussion with me and Mike in a couple of weeks. I pray otherwise.
Yes, I was going to say, I hope not, and certainly not in a couple of months.
All right. Well, we are always excited to see you guys. Of course, and we're always excited to have you guys on. Of course, even the previews or, even the reviews, all of your insights are absolutely fascinating. Now, I do want to thank you guys for your presentation. Like I said, we are always happy to hear your insights on various cases going through the Supreme Court, especially with so many pivotal events happening now.